I have mentioned yesterday to pass it over for a day, with the hope that today it can be disposed of. But since human problems are countless, yesterday I took a German and a grown-up NPA meeting. Today I am stuck up with another problem.
Okay.
And tomorrow is the division bench day. And from there to tomorrow again I'll be off for a few days.
Okay.
So may I pray that this matter will
Item 14.
maybe be tested next week.
Okay.
Monday.
When do you want? Monday.
Yes.
You are for a petitioner?
Respondent number 6.
Okay. Mr. C.T. Jamir, learned senior counsel, appearing for the respondent number 6, has sought for listing of the case on Monday due to his personal difficulties today. Post of it is submitted that the learned counsel for the petition and the other respondents have no objection to the no objection on listing of the case on Monday.
After 1 week.
Okay, not Monday. Okay. Then what is the agreed date? On another date, post of as agreed, sought for and agreed to by the learned counsel for the parties, list the case on when? 1 week means next month, Tuesday.
After 22.
After 22,
Yes.
23. Okay, 23, 6.
So, it's mentioned item 80, which you logically for other 2 weeks and we granted for filing my country.
Miss Livika, learned government advocate, has sought for a listing of the case after 3 weeks in order to file the counter affidavit on behalf of the state respondents in the meantime. Miss 2025 matter.
But the tenure of the petitioner is around 3 years. So,
What is the subject matter?
election of the
Selection of?
selection committee.
Oh, okay.
So, if there is only 3 years,
Okay.
1 year has passed.
Mr. Foseco Fotel, learned counsel for the petitioner, and who is for the respondents? Mr. So-and-so, learned counsel for the respondent number so are present. And to stop, in view of the subject matter, the state respondents will ensure that its counter affidavit is filed on or before the next date of listing. List the case on so-and-so. The interim order passed earlier. You are enjoying interim order. By virtue of that, you are continuing, I think.
No, sir.
Okay. The interim order passed earlier shall continue till the next date of listing. Give a date. Give a date after 3 weeks. Seven.
Signature is okay. This after 2 weeks. I have taken the consent of the opposition.
Okay. Mr. Baby Jimomi, learned government advocate, has submitted that the counter affidavit on behalf of the state respondents is being made ready, and the same will be filed within a week's time. Within a week's time, he has thus sought for listing of the case after 2 weeks. Full stop. Miss learned counsel for the petition and Miss who is for your name, please. Good name. Learned counsel for the respondent number 5 are present. The prayer made by Mr. Jimomi is accepted. List the case after 2 weeks on a date to be fixed by the office.
Your Lordship, we have for your Lordship here now is here. This other is such next week.
Your senior
This will.
for the respondent.
Yes, respondent is
Who is your senior?
SMG.
Okay. You are for the Mr. Ponjenar, T. Ponjenar, learned counsel for the petition is present. And who is for the state? Mr. Kumar. learned government advocate are present for the state respondents. A prayer is made on behalf of Mr. S. Temjem, learned counsel for the private respondent, on the ground that Mr. Temjem is indisposed. As the prayer is made with the consent of the learned counsel for the other sides, the same is accepted. Raise the case after 2 weeks. I did 2 weeks by the office.
Lordship, I think you mentioned item number 4 also. Lordship, I may kindly grant 2 weeks time to file a case in the private.
Okay. Mr. N.M. Koniak, learned counsel for the petitioner, has sought for and is granted 2 weeks time to file an affidavit in reply to the affidavit of opposition filed by the state respondents. Mr. B. Jimovi, private respondent. Okay. Mr. B. Jimovi, learned government advocate for the state respondents, and Mr. C.C.
Yes, sir.
and C.C. learned counsel for the private respondents are present. Okay. Raise the case after 2 weeks on a day, 2 weeks by the office. The interim order passed earlier shall continue till the next date of listing. Okay. No name is appearing in the respondent side.
Yes, I'm first.
Respondents,
Yes.
that is bank.
Yes, they,
Bank.
Yes.
Okay.
all the rest,
All the respondents.
taking the consent.
Okay.
I pray, maybe given, like, to follow our.
You have filed Okalanama.
Yes, I have.
Okay. Mr. Paki Richan, learned counsel, has submitted that he has entered appearance on behalf of all the respondents. He has already entered appearance on behalf of the all the respondents. First of, he has further he has sought for and is granted 2 weeks time, 3 weeks time to file the counter affidavit on behalf of the respondents. Post of. It is submitted that consent has been taken from the learned counsel for the petitioner to make the prayer. Post of. The prayer is accepted. Is the case after 3 weeks on a date to be fixed by the office. The name of the learned counsel who has entered appearance on behalf of the respondents by filing the number be reflected in the respondent side the causes.
Lordship, I'd like to mention item number 5. Lordship, here I'm yet to receive instruction, so kindly grant me 2 weeks of time.
You are for the state,
Lordship,
Mr.
I should be Lordship.
Learned counsel for the learned government advocate
Lordship,
for the state respondents has submitted that he has not yet received the necessary instructions to file the counter affidavit and has thus sought for listing of the case after
2 weeks, Lordship.
2 weeks in order to obtain the necessary instructions and to file the counter affidavit. Post of Mr. Moa Jamir, learned counsel for the petitioner. Madam, your good name, please. Rebecca, learned counsel for the respondent number 457 to 25, 27 to 32 are present. Okay, lays the case after 2 weeks, maybe 2 weeks. Like this. Yes,
So I'd like to mention item 6. In this matter, your Lordship, on the last occasion, I was given a final opportunity to file my contract with your Lordship. However, your Lordship, I have received another instruction from the department. The parties are negotiating to settle the matter, your Lordship, outside the home.
Mr. Moa Jamir, learned counsel for the petitioner is present. Mr. N. Angami, learned government advocate, has submitted that though by the previous order, the state respondents were given final opportunity to file the counter affidavit, as subsequent developments have taken place. He has sought further time. He has sought an accommodation for
4 weeks time.
4 weeks time to file the counter affidavit. It is submitted by him that the parties are in the process of have entered into a process of negotiation, and there is possibility of an amicable settlement. Post of it, the submission of Mr. Angami is not objected to by Mr. is accepted by Mr. Jamil and accounts board of petitioner. In view of the above, let the case be listed after 4 weeks.
I'm also like,
And also, the state respondents will ensure that its counter affidavit is filed on or before 4 weeks. In the event the process of regulation does not reach any finality.
right. Leave it alone.
For motion, item number 1.
May it please the lordship.
Yes.
I am appearing from item number 1 as petitioner, my lord.
Hmm.
My lord, here in the case, it's a pension matter, my lord. Here in the case, my lord, the petitioner was appointed as a stenographer 3 in the year 31/10/1987, and subsequently he was promoted to stenographer 1, my lord. And he was regularized, my lord. He was promoted to stenographer 1 in the year 29/6/1990, my lord. Thereafter, he was posted with Deputy Commissioner, my lord. The Deputy Commissioner has attached the petition number 1 with the revenue officer. When he objected, the petitioner was suspended eventually, and then he was put to the jail under the instruction of Deputy Commissioner 1. Then he was made to sign some letters regarding seeking apology, my lord, unconditional apology, and asked to voluntarily retire on the ground that his eyes have a defect, my lord. Thereafter, my lord, when he wrote the certain apologies letter, which is reflected in the page numbers, my lord, while he was in jail, my lord, page number 38, my lord, 37 to be precise, 35, my lord, annexure 6. He was made some apologies, my lord. He had given a handwritten type copies attached, my lord, and closed. Here it is written, I have the honor to state that I may be pleased to grant an apology for the mistake I had committed. Moreover, I am having acute eye problem wherein my official works at time gets hampered. I may also be granted to proceed on voluntary retirement. This was written while he was in jail, my lord, under the coercion by under the instruction of respondent number 3. And subsequently, there are more letters, 37, 38, where he stated that yes, due to some eye problem, then the respondent number 3 had suggested a medical board, had considered a medical board, where the medical board has given a certificate saying that yes, the petitioner is permanently incapacitated and having an eye defect. The medical board certificate is in the page number 43, my lord. Here it is, my lord may have it. If we consider Shantanu Bhatta to completely and permanently incapacitated of further services of any kind in the department which he or she belongs in consequences of eye defect, my lord. Thereafter, my lord, after giving the certificate, my lord, my suspension has been revoked. No departmental proceeding has been instituted against me, and thereafter we file a application for request of withdrawal my voluntary retirement, which is at page number 48, my lord. Which is page number 48, my lord. My lord, here it is written, I have the honor to refer the subject cited above and to state that without having been able to give a second thought, I have submitted my voluntary retirement on 17 September 2006 in my own handwriting, and subsequently on the 21st September 2000, contents being the same, where it was typed in an affidavit by Mr. Kamai, Superintendent DC Office, Kohima, so and so, so and so. At this point of time, I was lodged in that Kohima district jail, and mentally and physically I was agonist, and hence was not be able to decide in regard to my future. I had done so as the same was directed to my family by the authority concerned. I would also like to mention here that I had neither completed 20 years of my service nor had reached the age of superannuation. I am aware that I had made commission and omission for which I had been punished. At the same time, had also asked for forgiveness. When Lord Jesus so and so and can forgive the sinner, white and human, such and such, we have requested a withdrawal for the voluntary retirement. Thereafter, my lord, when the the then respondent number 3 did not consider my any application being agreed, we have filed a writ petition, my lord. The writ petition order is from page number 52, my lord. And the operative portion is from page number, my lord, page number 62. Paragraph 10, my lord.
Then you prefer repetition.
Yeah, being agreed with that agreed by the action of the respondent number 3, I have preferred a writ petition, and the order was passed in the year 2011, my lord.
For constitution of a medical board.
For constitutional medical board, and my lord, certain directions were given, my lord. In paragraph 10, it is written, in view of the above discussion, it felt necessary to direct the respondent number to principal secretary to the government of Nagaland, Kohima to constitute a medical board.
Then what happened?
Then, my
Then
lord,
what happened?
60 days has been passed, my lord. No action has been taken. Then we have filed a contempt petition, which is at page number 64, my lord.
Yes.
But, my lord,
What happened in a contempt petition?
But, my lord, in the contempt petition, it has been directed, it has been complied. No, as such, reasoning has been written. No documents, nothing, no medical board, as per the petitioner, which we have stated in the petition, that no documents, nothing whatsoever has been given, my lord. Now, since then, after the contempt petition, we are deprived of their action of responsibility.
What did you do for last 14 years?
No, my lord, that is one. Petitioner being the financial constraint, having very hardship financial, because I have been earning 21,000 per month. Now, when such an action has been taken up.
So how did you survive for last 14 years?
No, my lord, I have been survived with my wife's salary, my lord. With my wife's salary. I have been survived by that. I have been ill health throughout that.
What is your explanation?
My lord, it is on page number, my lord. Page number 20.
Why this petition should not be dismissed for delay and laches?
My lord, I am seeking for the pension, my lord. Pension can be granted even if there is long due, my lord. My lord, page number 24.
No, even in the issue of delay and laches sets in case of pension matters also.
But, my lord, in Honorable Supreme Court has already stated that.
Don't tell Supreme Court anytime.
Yes, my lord. But, my lord, my explanation.
But what about your explanation?
My explanation.
Supreme Court does not consider anything regarding delay or laches without considering the factual aspect.
But, my lord, my paragraph is in.
Delay and laches cannot be considered without going into the factual aspects.
Yes, my lord.
15 years. 15 years.
Yes, my lord.
Contempt petition closed, meaning thereby there is compliance.
No, my lord. My lord, still
Then you could have filed an appeal.
My lord, I could have filed a appeal, but due to my explanation, page number 24.
No.
Paragraph 24.
There was an order.
Yes, my lord.
There was a set of directions.
Yes, my lord.
In a writ petition in the year 2011.
Yes, my lord.
Then, alleging non-compliance of the direction, you filed a contempt petition.
Yes, my lord.
And contempt petition was closed when?
2014, my lord.
So, what is the order passed?
That it has been complied.
It has been complied.
Yes, my lord.
If it has been complied, if you have a cause of grievance.
Yes, my lord.
Right?
Yes, my lord.
As regards the order.
Yes, my lord.
Passed.
I would have filed an appeal.
Subsequent to the direction.
Absolutely, my lord.
Compliance of the direction.
Yes, my lord.
You should have preferred a writ petition then and there.
Yes, my lord. Absolutely.
Right. Or otherwise, if you were agreed by the direction, you could have preferred an appeal. But
yes, my lord.
15 years, where is after that?
I bowed down, my lord.
After the contempt order, when it was passed?
14, 11,
14. Now, from disposal of the writ petition, it is 15 years. From disposal of the contempt petition, it is more than
10 years, my lord.
10 years.
My lord, I bow down to that. My lord, my explanation is paragraph number 24 and 25, my lord.
Well, you should notice at this stage, but we keep the
My lord,
inability of the writ petition on the ground of delay and laches.
my lord, because my lord, my salary is at 21,000. My lord, my salary slip is at page number.
That is not the issue. First, we
Yes,
have
my
to
lord.
work on delay and laches.
I know, my lord, but my lord, the problem is that, my lord, due to my financial constraint and due to my
Yes.
hardship, my lord, I have been.
No, that cannot be. After 14 years, it
Yes.
cannot be.
Exactly.
If the same position continued,
Yes.
then after that, if you are living on wife's salary in 2011, the position continues today also. That you are living on wife's salary.
But my
That cannot
right,
be an excuse.
Besides that, your lordship, the decision taken by the state government to in compliance to the contempt petitions, your lordship. That this decision has been accepted by the petitioner and therefore has been remaining silent for the past 12 years, my lord.
but
And
my
you
lord,
will dismiss the moment. Heard, Mr.
A.R. Borua, my lord.
A.R. Borwal, Learned Counsel for the petitioner through the virtual mode, and Mr. N. Angami, Learned Government Advocate for the respond number 123.
Yeah. Yes.
Postal. Para. The petitioner was serving as stenographer grade 3. When he was when he was allowed to go on voluntary retirement, post of alleging that he was forced to apply for voluntary retirement on 17/9/2006. The petitioner preferred a writ petition WPC number 6 within bracket K of 2011. Post of the said writ petition was disposed of by judgment and order dated 25/11/2011 with a set of directions post of. After disposal of a writ petition, the petitioner alleging non-compliance of the directions made in the judgment and order dated so and so preferred a contempt petition, contempt case C number 460 2012. Post of the contempt petition came to be closed by an order dated 10/11/2014, observing that the order passed, judgment and order passed on 25/11/2011 had been complied with. Post of para. This writ petition has been preferred
My lord, my
by
consider
the
the financial.
petitioner seeking inter alia direction to the state respondents to release the pension to the petitioner as per Rule 49 within bracket 2 within bracket small a of the Pension Rules 1972, as well as for release of gratuity as per Rule 50 of the Pension Rules 1972. Full stop. Para Mr. Angami, Learned Counsel to State Government Advocate, appearing for respond number 123, has seriously raised the issue of maintainability on the ground of delay and laches. Post of it is submitted by him that after the judgment and order dated so and so, the petitioner filed a contempt petition, contempt case number so and so, which was disposed of on the ground that the judgment and order dated so and so was complied with. Post of thereafter, the petitioner had remained silent for a long period of more than 10 years. And the ground shown for preferring this writ petition after more than 10 years delay are not satisfactory. And as such, this writ petition is to be dismissed in limine. So
My lord, may
a
consider
matter would
the
require
financial
consideration, keeping the point of maintainability of the petition on the ground of delay and latches open. Issue notice returnable in 4 weeks. Steps. The petition shall take, as Mr. Angami has appeared and accepted notice on behalf of
No one will.
1, 2, and 3, issuance of formal notice to the said respondents is dispensed with. The learned counsel for the petitioner shall furnish requisite number of extra copies of the writ petition along with annexer to Mr. Angami within 2 working days from today. Who will accept notice for respond number 4? It will go by speed post or what? Accountant General?
So copy to be, just like he. Observe.
Okay. Okay, so and so, along with Mr. Posego Hotel and counsel for the petition, initially, madam, initially, along with Mr. Posego Hotel and counsel for the petition. And Joshua Seki, learned standing counsel, accountant general Nagaland for the respond number 4. So to Seki also, a copy, extra copy. Madam, extra copy to Mr. Seki within 2 working days from today. The issue of maintenance of the petition on the ground of delay and latches is kept open and the same will be considered at an appropriate stage.
Yes, ma'am. DPO bless.
Prohibition item number 3.
In fact, I received the instructions, however, most of you, the elections were found to be not legitimate. So I returned the same to me,
Okay,
responded concern, so that he should supply to me with the legitimate papers and elections. So
Mhm.
we have done a few this time with the president.
Okay, you are for?
Respond number 3, madam.
Okay. Miss Lucino, learned counsel for the petition. Miss Hurd, Miss L. Sanctum, learned additional LT Sanctum, learned additional advocate general for the respond number 1 and 2. How many private respondents under respond number 3? This is a different kind of, madam, this is a different kind of writ petition.
My lord. In my.
Under respond number 3,
Yes.
you have made many respondents.
My postal page 4 of my.
Okay.
Petition.
Since already no,
Mentioned the aggrieved party, but I have received the affidavit filed by them, and I also saw that
And-
there are 19 aggrieved parties, my lord. So if
Mr.
I will be allowed to
SOP.
verify these names and.
SOP learned counsel for the respond number 3. Oh, you named aggrieved party.
Yes, ma'am. And there appears to be 19 aggrieved parties, my lord.
What is being challenged here?
Lord, we are challenging the summons issued by the deputy commissioner to us. Notice is.
Okay, respond number 3 has already filed an affidavit.
Yes, my
Okay.
lord.
The respond number 3 has already filed an affidavit in opposition.
We be allowed to
Post
file
op.
a reply to this.
Miss, the Sanctum learned additional AG has sought for and is granted 3 weeks time to obtain the necessary instruction and to file the counter affidavit on behalf of the respond number 1 and 2. Miss Lucino, learned counsel for the petition, has also sought 3 weeks time to file an affidavit in reply to the affidavit of opposition filed by the respond number 3. Prayers made by Mr. Sanctum and Miss Lucino are allowed to release the case after 3 weeks. Indeed, 2 weeks by the office, the interim order past 30 days shall continue. Oh, it is already there till the disposal of the writ.
Yes, ma'am. That's all.
Prohibition item number 10.
Well, Mr. Lordship, I have received the relevant replies now by the petitioner, so Lordship, the next list is after 2 weeks.
Mr. J. Sekila and counsel for the petitioner is present. And Mr. Hart and Miss Pichano. Only state counsel or private respondents are there?
Police state counsel.
Okay.
The state is-
Ms. Pichano, learned counsel for the state respondents are present or heard. Okay, Ms. Pichano has submitted that she has received the copy of the affidavit in reply of the petitioner recently and needs some time to go through the same. She has thus sought listing of the case after 2 weeks. Post of pleadings are complete
Yes, Your Lordship.
as the exchange of pleading is complete. You can admit that petition
Your Lordship.
for hearing on a particular date. As learned counsel for the petitioners, parties have submitted that the exchange of pleading is already complete. The petition is admitted, release the case for hearing on after 2 weeks.
Lordship.
From the supplementary question list for admission, item number 12.
Yes. Oh, yesterday, Mr. Sanktam, there is an order. Yes. Is the office, let me, because this is a hearing matter, your matter is hearing matter. Yes, may I know your good name?
My God.
We don't find pleasure in calling for personal appearance, but there was an order earlier.
My God, I had this.
That order, I am told that that has been communicated. But in spite of that, there is no explanation for your non-appearance on the previous day. There is yesterday. So basically, we are interested in having the counter affidavit on record. We are not at all interested calling for personal appearance of any officer so that their duties are not disturbed, right? They can proceed with their own duties. But question was that the order of the court is to be respected. It is only for that reason, right? And had you filed a counter affidavit on or before 4/6/2026, we don't find any necessity to call for your personal appearance. That's all.
My lordship, we had already issued our comments and instructions. But because of some communication gap, it could not reach to the additional advocate, the learned counsel for the state respondent. So my lordship, if some time could be given to us, like 3 weeks time.
Mr. Sanktam, when can you file affidavit? Because the last date was over on 4/6.
Those are the communication.
Maybe now we'll dispense with the personal appearance of the deputy commissioner. But dispensing will not serve the purpose for adjudication or dispute. So when at the earliest you can file a counter affidavit, since he has already said that he has forwarded the instructions.
Well, unfortunately, I know the very instructions and programs that we send to the AG, not to us. That was the complication.
Now tell me, within what time you can file a counter affidavit? No, 3 weeks is already, all the instructions are here.
I'm yet to receive. I'm yet to receive.
No, he will be receiving it now from the deputy commissioner.
My lordship, we have all the papers with us. But if it could be submitted.
No point. By that time, it will be summer holiday.
I know. My prayer. Later come up with location.
Get it shortened by two weeks. Within 2 weeks. You file it, they have to respond thereafter.
Yes.
Right.
Yes.
Get it within 2 weeks.
Yes.
Okay, you are Mr.
Dhanraj.
Okay. But we don't find any pleasure for calling for personal appearance. Heard Mr. Foseko Fote. learned counsel for the petitioner, Mr. L.T. Sanktam, learned additional advocate general Nagaland, for the respondent number 1, 2, and 3, and Miss Jed Jimomi, learned counsel for the respondent number 4. Pursuant to in compliance of the direction made yesterday within bracket 8/6/2026, Mr. Dharmaraj, Deputy Commissioner Junior Bhutto, has appeared in person, post of on query. On query, Mr. Dharmaraj has submitted that the pairwise comments stroke necessary instructions to file the counter affidavit on his behalf was sent to the office of the Advocate General Nagaland on
13 March
May,
2026.
13 March or May? March.
My lordship.
Okay. 13/3/2026. And after consultation with Mr. Sangdam, he has come to learn that due to miscommunication, the said pairwise comments stroke instructions to file the affidavit on his behalf did not reach Mr. Sangtam. And it was due to such miscommunication, the affidavit on his behalf, which was directed to be filed on or before 4/6/2026, could not be filed. Full stop. He has submitted that he has handed over the concerned file and a copy of the pairwise comments stroke instructions already submitted on 13/3/2026 to Mr. Sangtam today for filing of the affidavit on his behalf. Full stop. Having considered the explanation provided by Mr. Dharmaraj, Deputy Commissioner Junior Bhutto, this court deems it proper to considers that as the pairwise comments stroke instructions and the concerned file have already been handed over to Mr. Sangtam for filing of the affidavit on his behalf, further personal appearance of his further personal appearance is dispensed with for the time being. If within 2 weeks it is not filed, then we may call for your appearance. Mr. Sangtam, Land Additional Advocate General, who has been handed over the necessary instructions, the pairwise comments to the instruction and the concerned file, shall ensure that the counter affidavit on behalf of the respondent number 1, 2, and 3, respondent number 2 is filed within 2 weeks' time. Okay. But madam, you have to seek leave, oral leave, at least leave, because your opportunity was also closed. Miss Jimomi, Learned Counsel for respondent number 4 has submitted that the affidavit in opposition of the respondent number 4 was filed on 8/6/2026 2026 and has sought as the time period for filing the affidavit in opposition on behalf of the respondent number 4 was also up to 4/6/2026. Ms. Zimomi has sought leave of the court for acceptance of the affidavit in opposition. First of, in view of the leave sought for, and considering the fact that the affidavit in opposition of the respondent number 4 has already been filed on 4/6/2026, the leave is allowed. Leave sought for on behalf of the respondent number 4 is allowed. First of all, release the case on after 2 weeks. It will be 24th. Release the case on 24/6. Division means 25/6/2026. The respondent number 2 shall ensure that his counter affidavit is filed. Affidavit in opposition is filed on or before 25/6/2026. So your appearance is dispensed with.
Prohibition, item number 4.
Yes, madam. You have initiated an inquiry. What is this PIMS, Mr. Jamir?
Personal Information Management System launching. That is for the employees, temporary as well as the permanent employees.
Heard Mr. Moa Jamir, learned counsel for the petitioner. Please take your seat.
Launch.
And Miss AIME, learned government advocate Nagaland, for all the respondents. Close to. By filing the present writ petition under Article 226 of the Constitution of India, the petitioner has sought for a direction to the respondent authorities to generate personnel information
Management system launch.
management system within bracket PIMS code in his name, and thereafter to release the pay and allowances, his pay and allowances from the date of his joining service in the post of driver on 9/6/2023. Post of. The background facts which have led the petition to institute the present writ petition can be exposited at first. Post of. Para. This engineering chief is your appointing authority otherwise?
Launch. Launch.
The engineer in chief, Nagaland Public Works Department, within bracket, the respondent number 4, published an advertisement on 21 2023. Inviting applications for filling up 9 posts of driver under the Nagaland Public Works Department, Nagaland, within bracket NPWD. Post. As per the advertisement, the minimum educational qualification required for a post of driver was class Roman 8 pass. And the applicant should have minimum driving experience of 5 years. Full stop. The advertisement further mentioned that the same was issued as per approval of the government of Nagaland, vide a letter number, page 17. First, second line. And with clearance accorded by Personnel and Administrative Reform Department, hide EO number 461 dated 21/12/2022, and the concurrence of the Finance Department by UO number 64/56 dated 11/1/2023. Post stop. The advertisement was subsequently published in the English daily newspaper, quote unquote, Eastern Mirror, in its issue dated 23/3/2023. Full stop. Para. In response to the above advertisement, the petitioner submitted his application. Full stop. In acknowledgement of the fact that the application was of the petitioner fulfilled the conditions of the advertisement, an admit card was issued under the hand of the respondent number 4, directing him to appear in a driving test scheduled at 9:30 a.m. on 9/5/2023. Full stop. The petition was allotted roll number 119 for the said purpose. Full stop. On receipt of the admit card, the petitioner accordingly appeared for the driving test at the time, date and venue mentioned in the admit card. Full stop. Para. After completion of the selection process and upon recommendation of the Department Recruitment Board, within bracket DRB, the results of selection were published on 25/5/2023 under the hand of the respondent number 4. Post. In the results, the candidates having roll number, page 21 out of 7, were declared as qualified on merit basis for appointment to the post of driver. Post of. In addition, a waiting list of candidates bearing roll number 21 were also published on 25/5/2023. Post of. Para. Subsequent to the declaration results on 25/5/2023, the petitioner came to be appointed in the post of driver grade 2 in the NPWD by an office order dated 6/6/2023, issued under the hand of the respondent number 4. Full stop. In the office order, it was mentioned that the order of appointment was made upon recommendation of the DRB dated 14/10/2022 and approval of the government accorded on 17/1/2023. Full stop. By the office order, the petitioner was appointed in pay level 3 in the pay matrix plus all other allowances as are admissible under the rules in force from time to time, with effect from the date of joining in the post. The order of appointment further mentioned that the appointee would be on probation for a period of 2 years, and on completion of the probation period, he would be considered for service confirmation, subject to fulfillment of the conditions prescribed in the service rules in force. On receipt of the office order, the petitioner joined in the post of driver by submitting a joining report on 9/6/2023, and the authority concerned acknowledged the receipt of the joining report on 9/6/2023. Post. The respondent number 4 on 19/6/2023 wrote to the respondent number 5 in reference to inform the respondent number 5 that the order of appointment issued in favor of the petitioner on 30/5/2023. This is different. Order of appointment issued in favor of the petitioner had been authenticated and confirmed as genuine. You are lady or you are lady?
No, Lord.
And the respondent number 5 was thereby requested to accept the joining report after observing all codal formalities. Full stop. After joining of the petitioner, the service book was also opened. Full stop. Para. When did you file the representation?
10/7/2024.
10/7/2024.
This is an acknowledgement receipt.
When after joining, even after though the petitioner joined in June 2023 and his service book was opened. Thereafter, the petitioner did not receive his pay and allowances in terms of the office order dated 6/6/2023 for a period of more than 1 year thereafter, post of having not, as the respondent authorities did not release the pay and allowances for more than a period of 1 year, the petitioner submitted a representation before the respondent number
Report.
3 and 4, which was requesting to release the salary to him. The said the representation was duly acknowledged, was duly received under acknowledgement by the offices of the respondent number 2 and 4 on 10/7/2023. Post of. As despite receipt of the representation, the petitioner has stated that the petitioner is compelled to approach this court by the present petition. As despite receipt of the representation on 10/7/2024, the respondent authorities appeared to have not taken any discernible steps to redress the grievances of the petitioner regarding non-receipt of salary for more than 1 year. Post of. Para. It is the case of the petitioner. No, post of. It is of relevance that the government of the Personnel and Administrative Reforms Department, Government of Nagaland, had introduced a personnel management system, quote, the Personnel Information Management System within bracket PIMS, unquote, on and from 21/4/2016. For addressing the administrative requirement of managing its employees right from the date of their joining into service till their retirement. Full stop. The PRMS system contains information supplied by the departments and the Personnel and Administrative Reform Department enters entries in the PIMS database and to generate unique employee code for each employee. Full stop. In case of all appointments made after 1/4/2016, the concerned appointing authority stroke department was required to forward a copy of the appointment order along with either post creation order or document showing vacancy against retirement, resignation, date, etc. And by filling up the mandatory fields for generation of a unique employee code for each employee. Full stop. By a subsequent office memorandum dated 4/3/2022, comprehensive instructions on the PIMS were issued by the Personnel and Administrative Reforms Department, Government of Nagaland. Full stop. It was mentioned that it was thereby mentioned that every head of department shall ensure that all legitimate employees are registered in the PIMS to prevent any delay or inconvenience in salary disbursement. And every entry to be made in the service book must also be updated in the PIMS. Full stop. It was reiterated that all mandatory fields were to be duly filled correctly. When the present repetition was filed, the state respondents filing an affidavit through the respondent number 1, affidavit in opposition through the respondent number 1, has have taken a stand you earlier approached. Huh? This is damn civil damage. Okay. Okay. Ha. Oh, no. Epidemic opposition, state response. Taking a stand that subsequent to the order of appointment made by office order dated 6/6/2023. No, I can leave. Has filed an affidavit. The state respondents have filed an affidavit in opposition on 25/3/2026. Post op. From the affidavit in opposition, it transpires that no a stand is taken to the effect that all these are in 2025. After filing of the affidavit, after filing of the requisition. In the affidavit of opposition, it is mentioned that after the advertisement dated 21/3/2023, the results were declared on 25/5/2023, wherein 9 candidates were declared successful on merit basis and 6 candidates were placed in the waiting list, with the petitioner as serial number 1 in the waiting list. Post op. For the post of driver in the NPWD, clearance of the Personnel and Administrative Reforms Department, Government of Nagaland, and concurrence of Finance Department were necessary for advertisement and recruitment through the DRB. Pusta. It is mentioned that the petitioner was appointed as driver grade 2 against an additional vacancy, which was neither advertised nor had prior clearance of Personnel and Administrative Reforms Department and concurrence of the Finance Department, and also approval of the government. Posto. The response number 4, that is the Engineer-in-Chief NPWD, while later dated 1/6/2023, had sought for clearance against the additional vacancy which arose in the post of driver in the meantime, that after declaration of the results, to accommodate the candidate at serial number 1 in the waiting list. Posto. In response to the letter dated 1/6/2023, the department, not the NPWD, while a letter dated 27/6/2023 had expressed its inability for appointment of a candidate from the waiting list against any additional vacancy in view of an office memorandum dated 24/3/2018 of the Personnel and Administrative Reforms Department, Government of Nagaland. Posto. A subsequent letter was also made by the it was again communicated to the response number 4 by the department through a letter dated 8/8/2023 to rectify the terms and conditions, to rectify the appointment made from the waiting list made in favor of the petitioner from the waiting list in terms of the office memorandum dated as the same was in violation of the office memorandum dated 24/3/2018. Para. It is thus the stand of the state respondents that the petitioner came to be appointed by the office order dated 6/6/2023. That is after the engineer in charge NPWD, within bracket the respondent 4, wrote to the government for clearance for appointment, but the appointment was made by the respondent 4 without waiting for the approval from the government. It is mentioned that the government approval mentioned in the office order dated 6/6/2023 was for advertisement of 9 posts of driver and not for the additional vacancy wherein the petitioner came to be appointed on 6/6/2023. Post. Para. It transpires that after filing of the writ petition, the respondent for pursuant to a government letter dated 8/9/2025 kept the appointment of the petitioner made by the office order dated 6/6/2023 in abeyance with immediate effect pursuant to the government letter dated 8/9/2025 by an office order dated 10/9/2025. Poster. The respondent for also issued a notification on 10/9/2025 in pursuance of the government letter dated 8/9/2025 for constitution of a committee comprising of 3 members with the chief engineer PWD RNB as within bracket the respondent of 5 as its chairman. Post up. The committee has been constituted to inquire into the irregular appointment of the petitioner in the post of grade 2 against a vacancy which arose due to promotion of the earlier incumbent. Full stop. By the notification, the committee has been asked to investigate into the matter and submit the findings to inquiry report within a period of 10 days from the issue of the notification. Full stop. Para. The present petition repetition has been preferred, seeking the reliefs by the petitioner, seeking the reliefs, mentioned above, already mentioned above. Full stop. From the stand taken by the state respondents, it transfers that the state respondents are of the view that the appointment of the petitioner made in a vacant post of driver grade 2 by the office order dated 6/6/2023 was an irregular appointment. Full stop. The relief sought for This court is of the considered view that the relief sought for in this petition is dependent upon the issue of regularity or otherwise in respect of the appointment of the petitioner in the said vacant post of driver gate 2. First of all, if the appointment of the petitioner is found to be regular, then his service particulars would be entered in the PIMS system, and after such entry, the petitioner would be paid the pay and allowances would be eligible to receive the pay and allowances in terms of the office order dated 6/6/2023. Post up. Para. As Miss Ami, and that whether that has been taken to any logical conclusion, inquiry initiated by the order dated. Okay, this something is there.
It's always in the next report.
Okay. The inquiry committee constituted by the notification dated 10/9/2025 submitted its report before the respondent number 4 on 23/9/2025. Question. Anything after report? Report is neither here nor there kept in evidence. On a query made by the court to Miss Amy, Learned Government Advocate for the state respondents. Miss Amy has submitted that no further instructions are received after submission of the inquiry report by the committee before the respondent of court on 23/9/2025. Ms. Amy has submitted that having regard to the having noticed irregularity in the process of appointment of the petitioner, a so cause notice has been issued to the incumbent who was holding the post of engineer in charge NPWD at the time of the appointment of the petitioner on 6/6/2023. So cause notice dated 19/5/2026. And outcome of the said contemplated outcome, I'm sorry, and so-called notice of the contemplated disciplinary action as on date, comma, the matter of contemplated disciplinary action pursuant to the said so-called notice has not reached any finality. Post one. While issuing a so-called notice dated 19/5/2000, the so-called notice has been issued pursuant to a decision taken in a meeting held on 10/4/2026 under the chairmanship of the respondent number 2. As part of minutes of the meeting, said meeting held on 10/4/2026. Comma. An observation was made that the noticee in the so-called notice dated 19/5/2026 while as the engineer in chief NPWD without observing due process and without getting clearance stroke approval from the competent authority, had appointed the petitioner to the post of driver grade 2. Post of. Para. As the inquiry initiated as regards the regularity or otherwise of the petitioner's appointment, regularly initiated on 10/9/2025, as regards regularity or otherwise of the petitioner's appointment is stated to have not reached to a logical conclusion, comma, this court is of the view that in such obtaining fact situations, comma, this the direction sought for by the petitioner in this writ petition cannot be allowed at this stage as is as the relief regarding his regarding entry of the petitioner service particulars in the PIMS system and consequent release of pay and allowances will be dependent upon the outcome of the inquiry already initiated against him. Full stop. তার আগত লিখিব it is the case of the petitioner that he participated in a selection process pursuant to an advertisement, and upon selection, upon participation of the selection process, comma, his name was as serial number 1 in the waiting list. Full stop. It is the further case of the petition that he had the requisite qualification and the experience of 5 years, prior experience of prior driving experience of 5 years, to be appointed in the post of driver grade 2 in the NPWD, right? These are you have, and therefore, after and there was and no fault can be attributed to him for denial of the pay and allowances even after extending service after his appointment on 6/6/2023. Full stop. The petitioner has canvassed that no one has challenged his order of appointment till date. And in such view of the matter, the action on the part of the respondent authorities is arbitrary. Taking into consideration the entire facts and circumstances obtained in the case, comma, this writ petition is disposed of with a direction to the respondent authorities in the NPWD. NPWD or
Yes.
NPWD?
Yes.
Okay. Yes, madam, NPWD. NPW, to the direction to the state respondents to bring the inquiry process initiated by notification dated 10/9/2025 to a logical conclusion by affording an opportunity of being heard to the petitioner, post of the entire exercise, if not on the Agwati, if not completed in the meantime, is to be so within a period of logical conclusion, with an opportunity of being heard, by affording an opportunity of being heard to the petitioner. So the entire exercise shall be completed within a period of how much time? 2 months.
3 months. Your Lordship.
Nothing is there. Everything I have recorded. You have to take a decision either to regularize ex facto approval or not ex facto approval, or if it is found to be illegal, you have to terminate. It is up to you. I will not advise. Since he has served, there is nothing here. It is due to your act, somebody's act. He participated in the selection process, participated in the driving test. He had the experience, he had the qualification, and he got appointed. There is nothing regarding corruption or something. Now, that engineering chief, he acted in haste. For what reason, I don't know. But he had acted in haste, but in a vacancy. One more. It is the further case of the petitioner that he came to be appointed in a sanctioned vacancy, which was available at the time of his appointment.
We transpose this another aspect, watching. He has already become overage, watching. But this year is completed 37 years.
Okay. It is, it is submitted by the Land Council for the petitioner that the petitioner has already become over age and no opportunity will be available to the petitioner as on date to apply for any government post. Okay, absolutely. Within a period of 2 months from the date of submission of a copy of this order at the office of the respondent for by the petitioner. Post of the matter of entry into the PIMS and release of pay and allowances to the petitioner, matters relating to entry of the service particulars of the petitioner in the PIMS and release of pay and allowances to him would abide by the final decision reached after the inquiry. I will abide by the decision taken upon completion of the inquiry. This order disposes of the petition. Will make some correction.
And
For hearing item number 11.
Next option.
Yes.
Also, the matter relates to regularization. And my respectful submission, the issue is already covered by a judgment contract on the bench of this honorable court, which has been approved by the division bench of motion. Only problem is that my learned friend, he does not agree with me. He is saying that this is not government. So the similar other matters were there, 380 petition that was been just disposed of in terms of our bench. And this has been separated. My learned friend says that it is not covered. So that is what the matter is stipulation.
Okay. What is the distinction?
So as I am concerned, as I said, it is already covered.
My lord, according to me, so far as this particular case is concerned, because on the earlier level, my lord, this honorable bench had dealt with 4 similar matters. Out of them, but the 3 I have fairly considered with slight modification, but this case does not covered by the judgment passed by the division bench. Reason being that, my lord, earlier, when Umavati case was enforced, the general principle that has been laid down in Umavati case is that any public employment has to be made consistent with the constitutional state. Now, when we say that appointment or recruitment should be made in accordance with the constitutional schemes, that is so far as the restraint rules for appointment must be consistent with Article 14, 16, and 309. If any procedure for recruitment is consistent with these 3 articles, then we can say that the due process of selection has been followed while recruiting this case. But in Umavati's case, an exemption has been carved out.
Uma Devi.
In Umadevi case,
Hmm.
I will make my submission short. I will like to pay my God to Umadevi's case, my lord. I will refer to only 2 paragraphs and nothing more. My lord, then first come to para number 38 at page 20. The first paragraph of page 20. Because before coming to this particular paragraph, I would like to only point out that the petitioner has been engaged on temporary basis as a contractual employee. But it is the case of the petitioner since he has worked for a considerable amount of time. A legitimate expectation would arise on his advantage that it is a fit case for him to regularize in the post that he was holding. Now, my lord, what has been held by the Umadevi's case in Kerala, am I allowed to read, my lord? When a person enters temporary employment or gets engagement as a contractual or casual worker, the engagement is not based on proper selection as recognized by the relevant rules or procedure. He is aware of the consequence of the appointment being temporary, casual, and or contractual in nature. Such a person cannot invoke the theory of legitimate expectation or being confirmed in post when an appointment to the post would be made only by following the proper procedure for selection and in concern basis in consultation with the Public Service Commission. Therefore, the theory of legitimate expectation cannot be successfully advanced by temporary casual or temporary contractual or casual employees. It cannot be held that the state has held out any promise while engaging these persons either to continue them where they are or to make them permanent. State cannot constitutionally make such a promise. It is also obvious that the theory cannot be invoked to seek a positive relief of being made permanent in the post. Now, member, legitimate expectation.
Now, what is the case about? I don't know the facts.
My lord, I am coming to the case here. Now, this particular paragraph laid down the general principle that has been involved. Now, an exception has been cut out from the general. That my lord will find at page 23, para 44. Right. If the case of the petitioner is covered by this particular paragraph, where
Paragraph,
she has a definite case,
paragraph.
paragraph 44. Right.
Hmm.
Am I allowed to read my lord?
Yes.
On one aspect, need to be clarified. There may be cases where irregular appointment, not illegal appointment, as explained in S.P. Narayana, R.N. Nana PM, Naga Razan, and refer to paragraph 15 of duly qualified person in duly sanctioned vacant post might have been made, and if employees have continued to work for 10 years, my lord, this is very good, or more, but without the intervention of order of the court of life, the question of regulation of service of this such employee may have to be considered on merit in the light of the principles settled by this court. In the cases above referred to, and in the light of the judgment, in that context, even if the state government and instrumentalities should take steps to regularize as a one-time measure the service of the such irregular employees. Not only this is the basic reason. Normally, contextual employees doesn't have a fundamental right to claim regulation or permanently absorbed in the sanction post. But if somebody worked in a particular department, government department, exceeding to the period of 10 years, then positive right is going to be created in his favor. Now, my lord, by this particular exception, my lord, the constitutional mandate to some extent has been compromised. And there might be a negligence on the part of the department that they have allowed somebody to continue their service for a considerably long period of time. So positive right is definitely accrued in favor of those employees. But whenever this kind of exception has been derived, there must be a strict interpretation while evaluating this kind of exemption. Now my stand is that so far as this particular petitioner is concerned, her tenure of service does not go beyond 10 years. Because by the time she has filed this petition, she has completed only 7 years. So she is not covered by this exemption. And this particular exemption has also been fortified in a recent judgment. That is, one is Jabu and another one is Molan Pilot. And technically it is distinguishable, but today I'm certainly not. Right now I'm not going into that aspect. But if my lord come to the case of the petitioner, first my lord may kindly come to the second paragraph. Why it is not justified to consider this particular petitioner for permanently absorbed. Now,
Yes.
then by advertisement number so and so for a walk-in interview dated 10/8/2017. Now I would like to take pause here for a moment. When walk-in interview, and she has also verified here that she is the only candidate. So no exhaustive process of selection has been followed, and that was she was the only candidate who participated in the interview. So there was we cannot say it should be gender is he. Sorry. He, I'm mistaken him to be extremely sorry, my God. But the thing is that he was the only person who participated in the interview. That would clearly mean that this particular selection process was not open competition. Had it been an open competition, my lord can consider his appointment to be irregular. But since he is the only candidate, and interview is just a walk-in interview, my lord. So his very appointment and selection process has to be considered as illegal. And thereafter, my lord may kindly come to page number 6.
No, it cannot be illegal. It was an advertisement. After all. And it was yes, it was an advertisement, and also it was published in national and local newspapers. So it is not simpliciter that walk-in interview. It was published in local and national newspaper. That is what it is stated in paragraph 3.
Yes. No, whatever that has been stated, and considering it to be. But the fact remains is that this is simply the walk-in interview, and she is the only candidate who has participated. in the selection process through this blocking interview. Now, matter may kindly come to para 6.
Now, it seems that the requisite qualification was postgraduate in horticulture and completed PhD on post-harvest management. So it is not a qualification like matriculation,
No.
where thousands would appear even in walk-in interview or in national newspaper. If you give one post of driver or peon having qualification of matriculation,
Absolutely.
in a local newspaper, thousands would appear. But a person having qualification of postgraduate in horticulture and a PhD on post-harvest management would be very few.
I will never commit this sin to undermine her education requirements. Let me clarify this very clearly. I respect it. Now I will kindly come in para 6. I'm only referring to the first sentence. Then thereafter, I later that will show 4/10/2017 addressed to the director CIRT Mexico in the Department of Agriculture, Cooperation and Farmer Welfare Ministry. The competent authority for engagement of the creation for the post of assistant horticulture specialist. Now, the very date of appointment shall be considered on 4/7/2007. Now, this particular petition has been filed in the year 2024. So, she has completed hardly 7 years in this service. So, her case does not fall within the exception that has been laid down in Umadevi case. And Umadevi case is a judgment of the constitutional bench because that particular judgment has been delivered by 3 judges. And
Five.
five judges. And that exception in Umadevi's case was the backbone of the moral case, which has came in the year 2026. And that moral case is the backbone of the judgment that has been passed by the order of this case.
What is the judgment you say?
But according to the your
Yes.
I will just take a worship, but before that, may I just make it take a worship to page 18. Just do an actual or take a worship to page 18 and it's your one. Worship has got it.
Yes.
Yes. As per advertisement number such and such dated such and such that in the national as well as the newspaper, the working in the and by selection committee. But also assistant horticulture specialist burial market basis. Now, last line of worship in bold. Dr. I was contributed as the petitioner of worship and was selected for also assistant horticulture specialist. Now, next page of worship 19. So this is written by the Ministry of Agriculture and Farmer Welfare. With worship to the director CI Central Institute of Agriculture, convey the approval second line worship, and that will refer to a regular legislation on that of mission circuit and convey the approval of for information of such and such. So, by way of advertisement, 14 national and local newspaper your worship, pursuant to that, I appear and I was recommended, and that the recommendation made by the selection committee was approved by the complete notary, that is by the Ministry of Worship. Now, pursuant to their worship, NHO 3 is 20. By this, I offered appointment, then 17, I was appointed. Though initially my appointment in contract was for a period of 6 months, your worship, my contract period was extended from time to time, your worship.
This was 4th of
Worship. Now, 28, 2021 extension, 2022, and 2023 or 2023 worship. This is the creation of post. Serial number 3, Your Worship. This is the sanction of the president is hereby accorded for creation of post agents. Serial number 3, assistant horticulture specialist, Your Worship has got it. So this is a sanction post. And here, Your Worship, you also take note of serial number 7, post-harvest technologist. So serial number 7, page 23, serial number 7, there. So I'll be coming to this also. Assistant horticulture specialist, this is sanction post. Post-harvest technologist is also a sanction post, Your Worship. Now, altogether, Your Worship, the total post is at the bottom 17 sanction posts, Your Worship, including the director. Now, since the petitioners were, page number 25 is the representation submitted by the petitioner along with others who are the petitions in the connected petition who has petitions in this post of Your Worship. Like, considering that they have been appointed to a regular selection process and are continuing in service for several years, they have submitted representation for representation. Now, in the meantime, Your Worship, page 26. The department again advertised with advertisement. This is for the post of post-harvest management expert, serial number 1, Your Worship. Your Worship has got it. Now, Your Worship, now, so the petitioner, he also applied because the salary is better, remuneration is better. We applied for the post, Your Worship. Page 27. So a committee was constituted, pursuant to the advertisement. This is circular dated 3/3/2024. Type copy is page 27A, clear copy. So this is a committee constituted for the post-harvest management expert, Your Worship. Then page 28 is the report of the selection committee. And as per the report of the selection committee, the combination serial number 1, post-harvest management expert, after was the summon number is the petitioner, Your Worship. Now, in the course of my submission, Your Worship, I will be also coming with serial number 2, same page, admin and accounts expert, which is MS Jamir, who is the petitioner in connectivity. Now I will be coming to this portion. So, Your Worship, now page 29 and 30 is the offer of joining petitioner. Since the petitioner, Your Worship, 29, he cannot join the new post without resigning from his current, he cannot hold both the posts. So he submitted the resignation from the post of assistant particular specialist and joined to his new appointed post of post-harvest management expert, page 30, Your Worship. Now, Your Worship, this is the page 31, NHL 12, Your Worship. This is the work distribution notification. And page 32, at serial number 4 and 6, Dr. Muasosan in charge, Dr. Muasosan. Though he is serial number 4, he is shown in both post-harvest management design. He is still continuing to be discharging the responsibility of assistant horticulture specialist, Your Worship. Now, Your Worship, may I take Your Worship to my prayer at page 15? Prayer 8, Your Worship. Your Worship has got it, page 15. Direct the respondent to absorb the service of the petitioner since his initial appointment that is to horticulture specialist. And also direct the respondent to request the service of the petitioner as post-harvest management X, which he joined subsequently, Your Worship. Now, paragraph 24, my petition. Page 13, paragraph 24. Here's one paragraph of the Your Worship. Paragraph 24, page 13. Your Worship has got it. It is submitted that when a similar suited case where appointment was made by way of regular selection process, this on report by common judgment on dated 27 passing the WPC 38 and the 39 of 2023 was placed to direct the scheme authorities to regulate the service of petitioner from the date of their initial appointment. So by relying on this, Your Lordship, the similar benefit claiming that the petitioner has approached this report by way of filing this present petition. Now, the petitioner in WPC 38, which was disposed of, who was serving as consultant technical, which is not a sanctioned post. And in the WPC 39 of 2023, the petitioner was serving as horticulture specialist, which is a sanctioned post. Now, Your Lordship, after filing of this which I will rely on this. So petition 38 and 39 of 2023 was disposed of by a common judgment in order. There is the first in order. Lordship, I'll take your to the last page, paragraph 29. In judgment passed by the division bench, I'll be referring to a few paragraphs, but so far as this is concerned, paragraph
Division bench.
Rate petition.
Rate petition.
Rate petition 38 of 2023. And the claim is 39 by common judgment order. Paragraph 29, the last page, Your Lordship. Respondent 1 to 4 are directed to regularize the service of the present petitioners from the date of their initial appointment. So accordingly, that was my first initial appointment question. Now, after
these petitioners were appointed when?
Lordship,
These petitioners were appointed when?
2006 and 7.
But this petition is 17.
7. But they have been serving for more than 10 years. But the present petitioner said 9 years now. Now, Your Lordship, during the pendency of the petition, the respondent has preferred an appeal against the judgment. So that appeal is April 12 and 13 of 2020. So this was disposed of by a common judgment order dated 7 to 2026. That appeal, Your Worship, I have given. So from here, may I refer to a few paragraphs, Your Worship. Whatever grounds has been taken by the parliament is discussed here. Paragraph 3, Your Worship. May I read out? The judgment order is the 7 to 2026, passed in April 12 of 2023 and being is. May I read out, Your Worship? The letter single judge by judgment and order dated 27/11/2024 directed the petitioner in both the petition should be regularized in the date of their initial appointment and further set aside the advertisement number such and such for filling up the vacancy of this. Indeed, this is what has happened, Your Lordship. Those two petitioners, when they were serving in that post, Your Lordship, advertisement was for regular appointment. So being they have been serving for more than 15 years. So being angry, their post is no longer seeking for regularization, Your Lordship. So in that petition, they have challenged the advertisement and seeking for a direction to regularize, considering the fact that they were appointed through advertisement, Your Lordship. However, liberty was granted to the respondent being to seek to start and the procedure of procurement for the other goods. That little being agreed by the same direction have acquired this court by filing the present review, raising various grounds of accession which are investigated. So the appellate here is the response. So the ground taken. Selection of permanent staff can be made through UPSC only by way of the process of conducting examination and interview, not walk-in interview. What? 2. The engagement of the respondent in the present appeal in the year 2006 and 7 were exclusive on terms and condition of engagement shall be purely on contractual basis, which the respondent here clearly accepted. So I have accepted the appointment, not the contractual appointment. 3. The question of regularization of the contract period for respondent here do not arise at all, because the recruitment rules of 2007 respect appointment on the position only, whereas the recruitment rules of 2083 respect appointment on direct recruitment only. The respondent further do not meet the various conditions laid down in the recruitment rules, as well as the rules of 2007 as well as 2002. It was also considered that the respondent hearing met the condition of recruitment rules of 2007 and 2022, even so, they would have to qualify and complete in examinations, training, interviews conducted by the UPS. Further to that, it is also considered that contractual appointment for respondent ought to be reversed as they were not appointed by following an open selection procedure as per the various conditions of the recruitment rules. The respondents are seeking regularization of the contractual period against Group A post, level this, not Group C and Group B post. Group A post can only be filled up by the UPSC. It is further considered that if regularization is permitted to the respondent, it would be a backward entry into public service and in violation of equal opportunity in public employment. It is further considered that the respondent never met the condition of the initial recruitment rules of 2007 and the amended recruitment rules of 2022, and if they are regularized, it would open floodgates for other contractual employees all over India. Para 5. Defects in verification. An advertisement that the deal was issued by CIS, Department of Agriculture and Farmer Welfare, Minister of Agriculture, and such.
Facts are okay. Now, tell me this Umadevi, after Umadevi, a number of decisions have come recently. Normal is, I have not read any of them. Because I normally, in the principal seat, do not sit in the service bench. Right. So there is no occasion for me. But still, whether this that Jaggo, then thereafter Bholana, then what else? What else? There are a few others now.
Your Worship.
I'm not read.
Yes.
Now, what criteria?
Yes.
I'm asking the query. I am not read it. What criteria have been laid down while diluting to some extent Umadevi for direction to regularize?
Yes.
Right. Any period, minimum period.
Minimum period is 10 years. No. What has been prescribed in Umadevi that the same
No,
question.
Umadevi is okay.
Yes.
Now, after that recent, any criteria?
This federal given to Amarnath himself in both the cases, Your Honor, the standard benchmark period of time for which a contractual employee needs to work for his or her consideration to be promoted is 10 years. That is for sure. Both these judgments are consistent.
Because slight distinction in facts, whatever principle is laid down,
Yes.
slight distinction in facts makes a whole lot of difference.
Yes.
Now tell me, in the recent judgments,
Yes.
which have been delivered, most of them by Honorable Justice Vikram Nath, perhaps, but the minimum criteria has been diluted. No. Period of service. Tell me yes or no. 10 years have been diluted.
10 years has not been diluted. But there is one exception, my God. The emphasis was more into the exemption that has been made in both settlement.
I
Private emphasis on.
have not read any of them.
Yes. What my learned friend is saying is relying on the 10 years. 10 years is a system around before the SEC, but in SEC online.
No, I'm not asking about Umadevi. Umadevi, if it is there, we have read now.
Yes.
No, but in the recent cases regarding regularization, Umadevi has been diluted to an extent, right? Admittedly.
Lordship.
Now, whether this experience continuation criteria in the same post for a minimum of 10 years have been diluted or not diluted?
Yes.
Not that. Let us have that, because slight distinction in facts makes whole lot of difference. These are 2006, 2007 appointments.
Now let us come to the root questions. If it is so, then there is a case for litigation.
Because we cannot go against Supreme Court judgments.
Lordship, I have.
Let us have it just a glance.
In fact, your Lordship here, earlier.
First, take me to their appointment. First.
Para 4, your Lordship. Your Lordship, is a good.
This is Holanath.
Bolana. Bolana will be,
Para 4.2.
para 4.4.
4.2.
Yeah. No.
4.2.
4.1, Lordship.
4.1 is the advertisement, 4.2 is the appointment.
There's against Supreme Court.
Office order, 2012. Now let us see, Joggu, what kind of post it was.
No.
This is 1993. 1998. Anyway, just a principle. I am for the principles. This 1993, 1998, 1999. There are a few others.
No,
There are a few others. No, because if I vote, I have to dilute again. No, this is which may not be possible on my part. These two are different. These two are similar. This division bench judgment and the other two, they were 2006-7 appointees. Other three, there is no issue about that. You can assimilate those cases with Umadevi and all these. But this is a bit on a different side, factual. 2017.
Except for
the principle is that Supreme Court has not diluted as on date 10 years. Show us anything where it is diluted. Otherwise, it will be difficult on my part.
In my respectful submission, Your Worship, that period of 10 years, in SEC it is paragraph 53, but in online it is paragraph 44, Your Worship. Now, if I am seeking for regularization.
See, Umadevi has declared regularization illegal, but subject to certain recruitment process, advertisement, all. Now, there also the Umadevi says it's called 10 years.
Yes.
No doubt about it.
Now, if it is as per the scheme, under the scheme, Your Worship, then yes.
I have not understood in that way. And I am not possibly will understand in that way, Umadevi. That where is show us something that which is less than 10 years.
No.
If the 2 judgments or 3 judgments dilutes that to an extent, because these two are factually different.
The Lordship may kindly come to the judgment passed by the pass and read actually.
No. My question is basic question.
Lordship.
See the distinction I have noticed. Right. And whether this 10 years period has been diluted by the Supreme Court for regularization. Show us something, because I cannot depend upon this because of Uma Devi. And these two have not diluted that 10 years barrier. Neither the division bench, nor the single bench.
In my estimate, using your lordship, subject to your lawsuit inspection, related to your lordship, where Big Jampu or Kolana, your lordship, that 10 years, that mandatory, that period is not stipulated, your lordship. Now, if someone has been appointed by whoever.
Show us something more, because this they have done within the parameters of Uma Devi. Because otherwise, this will create because regularization, which is otherwise abhorrent to the Article 14 and 16, but subject to certain exceptions. Now, Uma Devi has said, and all these Uma Devi says, henceforth, no. But whatever earlier happened, one-time measure. But taking cue from that, all these judgments have come. Even after Uma Devi, 10 years, keeping in mind 10 years, they have advertisement, so and so, something. Okay, done. Right. But who has breached? Which judgment has breached? Uma Devi barrier of 10 years.
10 years.
Yes, my lord. I will be allowed to, because older that case, this judgment in the year 2086, I consider it to be latest one. I will then other one. Then kindly come to para number 13.1. I will not read that paragraph, but I would like to point out something. Now, so far as the para number 13.1 is concerned, first, these judgments refer to the paragraph which I have already read. Now, I shall not be reading again, but para number 13.1.
13, yes.
Yes, this is the paragraph, my lord, I have read. Now, my lord, may kindly come to the another part. I have this code in Uma Devi's case. However, this code clarifies that the bar against invocation of doctrine of legitimate expectation applies only to those temporary contractual or casual workers whose engagement was not preceded by a proper selection process in accordance with the extent and consequently where the engagement is made after currently due and proper selection procedure, there is no absolute ban in law preventing such invoking the doctrine.
Now, 13.2, the course observation. See, in a present case,
Respondent had engaged his service of an applicant on sanctioned post since the year 2002. It was only towards the end of the 2022 that the respondent communicated had no further extension of the applicant's engagement.
that did not breach 10 years. That is why it has specifically noted after 10 years, they tried to stop the further extension. Show us anything. Otherwise, I'm in favor, but I, in the process, I'm not going to breach 10 years. No, I'm not in the, I keep it. But the question is, show us where the Supreme Court and even our coordinate bench breach, I'll say parity. But question is where it has breached the 10 years minimum period to make it 8 or 9 to direct regularization. Because I have to be careful about that, because this will set a bad precedent. I'm in favor of the petition. Right. But question is that if I make this, I breach that limit of Uma Devi, knowing fully well, then it will be a floodgate. Like anything. You have all the factors in your favor. Advertisement, qualification, participation in the interview, whatever. Just because national newspaper advertisement, local newspaper advertisement, right? Philosophy, PhD in the subject, MSc in the subject, sanction post, all are there. I quite agree with you. But show me something which has breached the 10-year limit for directing regularization. You may find it either Supreme Court or just a minute, please hear me out. Hear me out. Either Supreme Court or division bench and or a coordinate bench. Even if you find, then I will draw parity and closing my eyes, I'll say a coordinate bench is observed.
But should we give you some time?
Sure,
No, sir.
but show me to
No, sir.
keep the handle. Otherwise, I am conscious.
No, sir. I have understood your question. Okay.
I am conscious. So this show us anything. I am saying three options:
No, sir. I have understood.
Supreme Court
Or coordinate bench.
or division bench of this court, or some judgments are of him. Okay, you keep your judgments and give the others to Mr. Jamir. And your Uma Devi, no? Uma Devi. Here, Uma Devi.
One more judgment in the filings, sir.
No, you keep it. No. So, I have asked Mr. Jamir to show us anything, either of the three. Supreme Court, very well. Division bench of our judgment, well. A coordinate bench, okay. Where it has breached 10 years. Because on that count, we can enter into the arena. This is, otherwise, I should not be the first one to breach that. Right. Otherwise, at least I don't, even if I don't take service bench, at least I am aware this about 10 years. One, if you can satisfy, I keep it after vacation, like if you want. In the meantime, you do your research. He is not also averse for your regulation, subject to law, subject to law, as it is found out from his submission. He cannot concede. But question is, show us something, some handle to the court, will be okay. Because I should not be the first one to breach. Right. We will not observe anything after vacation, any fixed date, since he is an outstation counsel. Sure. We'll have vacation up to reopening on 13th of July. Later part of July? 28th July? Okay. As sought for and agreed to by the learned Mr. T.B. Jamir, learned counsel for the petition, and Mr. B. Decca, learned settled government counsel for the respondents. List the case again on 28/7/2026. So just show us something. So that is why I have returned those, find out if somebody has breached 10 years, then it's okay. Otherwise, you keep working. And if they want to terminate, come again. If they don't extend it, then Mr. Decca, there is a caveat. Just because we are not hearing this matter out, don't take any course of measure.
We will not take it.
Because he, the specialist is here and now over-aged,
Yes.
and he doctorate in a subject matter, and it needs the service. And even after second advertisement also, He qualified in a higher post. But question is that breach. Right?
So,
Thank you.
Forget nothing. Good motion. Take